Hello, in this lecture we will cover uh, one of the most complicated parts of property law. We will introduce property law, we will introduce primary and secondary property rights, and we will take a lot of time to explain secondary property rights, which are actually very complex. Afterwards, we will say something about the modes of acquiring property. This lecture will not cover the whole of property law. There's a lot of it that will be covered later in the tutorial and through self-study and in a catch-up presentation after our discussion in class. Be warned that property law is one of the most technical and difficult chapters of the book. It's also one of the longest. This is because property law is a very technical subject. You will immediately see the contrast between property law and tort law, because property law is crisp and full of very specific rules of who owns what, whereas by contrast tort law is very fluid because of the fluid and unpredictable nature of torts. Now let's get started directly with property rights. It's good to begin with the most general classification of rights in the civil law. The civil law classifies rights in personal rights and property rights. Personal rights are also called relative rights, and property rights are also called absolute rights. I'll explain precisely what this means. A personal right is a right that you have in relation to a specific person. That is to say, it's a right that impinges on you, or somebody else, and that cannot therefore be transferred or claimed against somebody else. And therefore, for example, if I have a contract that you should come and fix my coffee machine, and you don't do it, then I cannot ask, let's say, your brother or your neighbor to go and do it, because the person will rightly say, but what are you to me? We have never talked. We do not have that agreement between us. So a contract right, as a personal right, is one that you can only claim against one specific person. A little bit later, when we do torts, you'll see that those are also personal rights. So if you drive your car in such a way that it damages my fence, I can ask compensation from you because you did it, but I cannot ask compensation from your brother, for your neighbor, and so forth. On the other hand, we have property rights, and property rights are called absolute. And here, what absolute means does not mean that there's no exceptions. What absolute means here is simply the opposite of relative. It means that these rights can be claimed against anybody else. And then if you think about it, it's pretty trivial. So if I am the owner of this water bottle, and then you come try to take it away, and of course I know you, but I say, well, hey, this is my water bottle, you cannot take it away. But if then somebody else who I do not know takes it away, I can still say, hey, this is my property, give it back to me. So if the person says, but there's no relationship between you and me, that doesn't matter. There doesn't have to be a relationship. My relationship is with my property, and I can claim my property against anybody. And in that regard, property rights are absolute rights. In contrast to personal rights, they can be claimed. In the Latin term, we use the Latin expression erga omnes. They can be claimed against anyone. So we said we're going to talk about property rights, and property rights are absolute. They relate to a certain thing, and then they can be claimed against anybody else. But first, before getting into property rights proper, let us say that there is more than one way to relate to a thing. For our purposes, we should distinguish between material relationships with a thing and jural relationships with a thing. So material relationships with a thing, that's, very simple. If I have my glasses in my hand, that's me, myself, and a thing, and we are now in this interaction. So these material relationships with a thing, they are actually legally important, although they are not rights. Rights are immaterial. There are two types of material relationships that property law considers. Possession and detentorship. In the case of possession, I am in control of this particular thing, but I also claim it as my own. I am in a physical control of the thing, and I stand vis-a-vis others saying, hey, this is mine. Either explicitly, hey, this is my water bottle, or implicitly, if I have my water bottle and I start to drink it, that would mean I am claiming to be its owner, because those are things that only owners legitimately do. Detentorship, by contrast, is when you have some control of some material thing, but you recognize that it's somebody else's. So if I have the water bottle, I don't drink it, and if anybody asks me, oh yeah, I'm just holding it for Carl, who just went there to pick up his children, and I have the water bottle because they want to drink the water, that would be detentorship. Detentorship can also happen in an implicit manner. For example, if you have a room and you pay rent every month, the paying of the rent recognizes that you are not the owner. These material relationships of control can be contrasted with the jural relationship that property is about. So property rights, properly, they are not physical control, but legal control. So then if I am here in Maastricht, I can tell you I have property in Ecuador that is 1,000,000 miles from here, but it's still mine. I have no physical control over it. Maybe I do not even know where it is, but legally speaking, those things over there are still mine. Now, these material ways of relating to a property, possession and detentorship, they can be very important for the law, because depending on whether you are a possessor or you are a detentorship, or you are a detentor, your there can be future consequences of this. For example, if I am a detentor of a thing for a very long time, in principle, it will remain, whoever is the owner will remain the owner. But if I am the possessor of a thing, if I take it and claim it to be my own, after the passage of some time, I may become the owner through the law. And so, for example, this may happen if I, let's say 50 years ago, I enter a terrain because I just don't know who the owner is, and I enter a terrain and start to farm there. The terrain is abandoned, and for 50 years I've been farming there. After a certain passage of time, the law will say, okay, you've claimed to be the owner of this terrain for a sufficiently long time. We might transfer to you. We might rather, it wouldn't really be a transfer. We might consider that you become the owner of this terrain. It may appear striking to you that somebody who's not an owner can become the owner simply by the passage of time. This has a little bit to do with what I commented in some tutorials, that the law will, at certain scenarios, prefer predictability over fairness. So if you've been working in the land for 50 years, maybe you have expectations to be there for 50 years more, and then other people around you also have the same expectations, and then at some point the law will say, okay, I prefer to keep to these expectations than to say maybe this law was not yours to begin with. This power of possession to turn into property, to turn into an ownership right, is modulated by the form, let's say, by the quality of the possession that takes place. So there are actually two ways in which you can come to possess something. You can come to possess something in good faith, or you can come to possess something in bad faith. To possess something in good faith means that you have legitimate reason to think that that is yours, and then you just simply say, okay, I take this, I claim it as my own, and I reasonably can believe that this is my own. And this sort of possession might happen if you buy something secondhand and you have it for a very long time, and then you find out that it's stolen. For the long time in which you were possessing this object, you thought you had fairly bought it. So that would be possession in good faith. Possession in bad faith, in contrast, will arise when you take possession of something, but you have either knowledge that it's not yours or good reason to believe that it's not yours. So going back to the example, if you find this plot of land and you simply take it, and you see that somebody tells you, hey, this land belongs to Mr. blah blah blah, and you say, okay, but he's not here and I need to farm, I need to eat, that would be possession in bad faith. So bad faith does not necessarily mean that you're doing something evil, it just means that you know that this is not yours. Then if you have a CD or a book of a friend and you leave from your country to Maastricht and then stay there for 5-10 years, you know that this CD is your friend's. Again, this might be possession in bad faith. Possession in good faith and possession in bad faith will transform into property in different ways, or rather with a different time frame. And to give you an idea, with possession in good faith, what you possess, you become the owner in, let's say, 5 years. And bad faith, it could be 15 years. So by the way, these sorts of transformation from possession into ownership is something that operates at a very, very long time. All right, so far so good then for this material relationships with the thing, these forms of control over a thing that could be qualified as detentorship or possession. Now let's get back to rights, this immaterial, this dual relationship with some object. Now, essentially, in property rights, you have two types: primary property rights and secondary property rights. Primary property rights, there's only one, and it's called ownership. Secondary property rights, there's quite a few. We will cover 3: usufruct, servitude, pledge, or hypothec. These primary secondary relationship exists exactly in the mode I'm going to explain right now. What it means to be primary, what it means to be secondary is what I'm going to explain right now. So the primary property right, that is ownership, must be understood as the widest possible right you can have over a thing. Let me use words that are strong and therefore capture this idea: absolute dominion, absolute sovereignty over that particular thing. In the Roman law, ownership was classically defined as having the right to use, enjoy the fruits of, and also abuse a particular thing. So they said usus, fructus, and abusus. So then, for example, if you have a tree, you can use the tree to climb it, to build a tree house. You can enjoy the fruits of the tree. The fruit gives apples, then the apples are also yours. Or you can turn the tree into firewood, which would be destroy, abuse the thing. And there you see that you have this total control, total dominion, in the sense that primary property right, the ownership, extends to all possible actions that you can have over the thing. Okay, so that is very powerful. You can immediately see that these sorts of rights could never legitimately fall to a person. So you have persons and you have objects. And what was horrifying of slavery in its full manifestation was that it applied a legal regime that is fit for objects. It applied it to persons. To extend the power of usus, fructus, and abusus to a person is probably the ultimate injustice. So in any case, this is how naturally you would understand ownership as the primary property right, as this sort of maximum dominion, maximum authority, maximum sovereignty over a thing. And now the secondary property rights, what makes them secondary is that they are limitations, encumbrances, things you cut away from that full ownership for the benefit of somebody else or of something else. And what that means will be explained just in a little bit. For now, let me just present it in this manner so that the label primary, secondary makes sense. So you take something away you limit something of that full unrestrained sovereignty for the benefit of something else or somebody else. And I will explain exactly what that means. But then get this idea of the primary-secondary relationship. Primary means you have complete total dominion over a thing. Secondary means you have dominion over a thing that is almost complete, but it's not complete because some aspect of that right has been granted to somebody else or to something else. So let me explain this concept of the secondary property right by introducing first the property right, the secondary property right of servitude. Now, let's say I am the owner of this terrain right here. So this is an agricultural land. Over here you have the river. What this land is good for is for herding cattle, for herding cows. And then as the owner of this, I can do with this terrain whatever I want. I can use it, I can enjoy the fruits of it, for example, the grass that grows there, that's also mine. I can abuse it, and well, for example, I can dig a hole in it, probably not in human power to destroy it, but you see, I can dig a hole in it, I can take the grass out, use chemicals to erase the grass if that's environmentally feasible. So I can do many things with this terrain because I am the absolute sovereign of it. I can also keep you away from it. You can say, this is my land, you shall not trespass. You cannot go into this terrain if I do not consent to that. Now, let's say there's another terrain over here, terrain B. It was also owned by somebody else. And naturally, this person also is raising cattle because that's what this terrain is good for. Now, in the event that we're just full owners, that description is as far as it goes, and the owner of this terrain B cannot cross into my terrain without my consent because, as I said, I can exclude whoever I want. But then it may happen that the law, for example, the land law or the municipal law, might establish a servitude, a secondary property right, for the benefit of this terrain B. And what that would mean exactly is this. That means that there will be a restriction on my full ownership of this terrain B. I will be able to do with it whatever I want, except one thing. Except that there's a servitude of way by virtue of which the owner of B can cross, take the cattle to the river to drink water and come back. So now terrain A, I'm still the absolute sovereign of this terrain. Yes, except for one thing that I can no longer do. I have full control, full authority over that terrain. I can do with it whatever I want, except I cannot exclude the crossing of the cattle from terrain B to the river and back. So now terrain A is property minus, is ownership minus, because one aspect of that ownership has been handed over, has been clipped from it and handed over for the benefit of terrain B. So in that regard, this primary property right has been encumbered by the appearance of a secondary property right that reduces its scope. Now let me give you an example of a different type of servitude that does not appear in the book so that you get more versions of the same idea. Okay, so now this is my house right here. And one of the things I have is a very nice pool. And that's the value of my property, of course, is highly dependent on the existence of that pool. And both the enjoyment I get out of it, or if I were to sell it, that pool is going to count for a lot. Now, it's my house and I can do there whatever I want. I have full ownership over it. Now, there's somebody else that has the ownership of this terrain over here, and he has this hotel right here, and then he's also the full owner of that hotel, and he can do in that hotel whatever he wants. He can change it, put luxury windows, he can bulldoze it, and he can turn it into a store. He can do many things with it because, again, full ownership. But now, what would happen if the owner of this terrain says, okay, I actually want to make a mega hotel. So I'm going to do this, and this, and this, put more floors on top of the hotel. Now, that's probably going to be more profitable for him, but then what's going to happen to my pool? What's going to happen to the value of my pool? Well, if this hotel is here, then my pool will no longer really receive sunshine. It will no longer receive light. My value of my property will be very strongly negatively impacted by the creation of a high-rise building right here. And then one of the things that the law might do is create a servitude once more. Now, a restriction on this property right A for the benefit of my property right B, which means essentially this. You are the full owner of that terrain, you can do with it whatever you want, but this one thing you cannot do is build more than 2 or 3 stories, because at that point you create too much shadow for the adjacent terrain. This servitude, which is charmingly called servitude of light, it's again the same pattern, a restriction on the full dominion of one property for the benefit, in this case, for some other adjacent property. What about for usufruct and pledge? I think we can follow the same logic here that has been explained with servitude and understand them as restrictions on your property for the benefit of someone else or something else. So in the case of an usufruct, essentially you will have, let's say, the ownership of this house, and then if you leave it at that, then you can, as I said, use it, enjoy the fruits of, abuse it. In the case of the house, there are no fruits, but you could use it, you could abuse it, you could destroy it. But if you give a usufruct, that means that for this house, there's somebody else, some other person who's not the owner, let's put him right here, who has the right to enjoy the house. He has the right to use the house. Does that sound like a rental contract? It's actually similar to some extent, but it's also different to another extent. So in this similarity, I will explain it in a little bit, but just think about it in these terms. So this is my house. I am the owner, but I can no longer really use it because the right to use the house, that aspect of my property, has been given to somebody else. Hypothec and pledge are a little bit more complicated because they are actually something that arises in a larger transaction. But these are also rather common, so you probably know them from, let's say, common sense or normal life. So let's say you buy this house. How much is this house worth? Let's say 400,000 euros. Very few people have 400,000 euros cash in a big bag somewhere. Most people have to buy something like this on credit. So what buying this house on credit means is that you're not going to pay for it up front. There's somebody else who's going to pay for it. In this case, it's going to be the bank. And you yourself will have to pay the bank monthly installments, let's say 500 euros per month, that will go to eventually pay the value of the house. That will be with a certain interest calculated, and that's the financial calculations are for the economists, but that's how it goes. But okay, but what happens if now let's take the perspective of the bank. So 500 euros per month to pay a 400,000 euro house, that's gonna run for a very long time. That's gonna take a long time. And in that long time, many things can happen. You may, for example, lose your job and then not be able to keep paying the loan. And then what will happen to the bank? For the bank, it would be a disaster if in the middle of things you stop paying your credit. Of course, it's not just that it's bad business for the bank, but if that systematically happens, it can essentially cause enormous harm to this credit system and hurt other people, hurt third parties that also depend on the bank. So the bank needs a security. It needs an assurance that if you're unable to pay, the bank can recoup its losses in one way or another. And then what traditionally gets done for assurance is that the bank creates a hypothec on the house as a way to guarantee the loan. And the hypothec as a secondary property right, what it means is that, okay, you are the owner of the house, you have the primary property right, means you're full owner of the house, you can do with it whatever you want, but you're encumbered. Your full ownership is shadowed, your full dominion is shadowed by a condition of the hypothec, which means, amongst other things, that if you stop paying the credit of the bank now can take control of the house and sell it as a way to recoup its losses. So then this is, again, are you the owner of a house if you buy a house with a hypothec? Yes, you are the owner, because indeed you bought the house with a hypothec. It's yours, but it's yours not fully. It's yours with a shadow, and that comes with a series of restrictions. Among them, the biggest one, the most important one, is that if you stop paying, now the bank can take ownership and sell the house to recoup its losses. And here you have the secondary property right operating as a security, that is to say, as an assurance for some other credit. This other credit would be a contract, by the way. Now I need to explain something that I highlighted just a few minutes ago. I said, be careful to note that property rights are not contracts. Secondary property rights are not contracts. For example, the usufruct might look like a rental contract, but really it is not. So this is the best way I can explain it. Let's go back to servitude. Remember, there were two terrains, that they were adjacent a river, and that one terrain A had a restriction for the benefit of terrain B, such that the cattle living in terrain B could always cross and drink the water. All right? Now, let's say the owners at this original time T1, the owners of these terrains are respectively John and Peter. Okay, so John's ownership is shadowed by the existence of this limitation. Now, after a passage of time, John sells his terrain to Mary, and Peter sells his terrain to Sue. Mary and Sue do not know each other. They've never met. You know, they do not have any sort of working relationship. And now the question is, can Sue take her cattle through this terrain so that the cattle can drink water? The answer is yes. But note, if this were a contract, the answer would have to be no. If this were a contract, remember, contracts are personal rights. They're only against a particular person. So then if I say, hey, I will pass through this terrain, who are you? I never made anything in writing with you. I've never made any agreement with you. You just have to stay away. But it's not a contract. It's about property. This is a restriction that it's inbuilt into the land. And then whoever is the owner of this land has that restriction for the benefit of whoever is the owner of this other land. And in that regard, it's quite different from a contract. Now let's go back to the usufruct example, and I will show to you that this is also different from a contract for a different reason. So here it's not, usufruct is for the benefit of a person, not for the benefit of the land. And in that regard, it's the difference that I made over here would not be 100% applicable. But let's see what happens. Okay, if I am renting this house and the owner of the house sells the house to somebody else, what would happen to my rental contract? The answer is that rental contract would be terminated, would possibly breach, but the rental contract would be terminated, because after a house is sold, the buyer is going to say, who are you? We don't have any relationship. Your contract covers a relationship between the other person when he was the owner, but we have no agreement. On the other hand, if you have a house with a person in usufruct and you sell the house, you know what happens to the person? The person goes with the house, because the relationship of this person is not to a landlord, it's to a property. If the property changes owner, that's no problem for this person. This person would say, okay, I don't care who the owner of this is. My relationship is with the house, not with the owner, and I'm staying here. Now, sounds very weird, and as it should, because this would never happen. This is very archaic, and in modern times this will not even get used. But the logic of this being a secondary property right and it being different from a contract is something that you have to take home. Another reason why this is different from a contract, and this is something that you can see in usufruct, has to do with duration. Now, this is a little bit more advanced, and therefore it's a little bit outside the scope of this course. But contracts have, by law, they can not normally extend for extremely large amounts of time. Now, I cannot have, let's say, a rental contract for the rest of my life. That would be considered, as contract law is very commercial, that would be considered an undue restriction on the fluidity of commerce. But by contrast, a usufruct, which is not, so property law is less commercial in nature. It's more than commercial. It has to do with things, that property being much of a permanent thing, or supposed to be more of a permanent thing in life. Usufruct as a property right would not have that restriction. So then, instead of granting somebody a rental contract, which would have to have some sort of definite duration, you can definitively grant a usufruct for the rest of your life. That's indeed one of the reasons where usufructs were used. Somebody wanted to transfer the house to his children, but then said, okay, but I don't want to end up homeless. I don't want to end up having to go to some sort of asylum. I will transfer the house to my children, but I will keep the usufruct. For what duration? Until the end of my life. Then that would be possible. And here you can see that, I guess by now you should have the full logic of secondary property rights as encumbrances on the primary property right and as being different from contracts. Okay, let's just add one more difference. And this is probably the most complicated one. Another way in which property relations differ from contractual relations is that property relations have a prior tempore principle, which means essentially that if two property relationships exist, the oldest one wins over the newest one. Whichever is oldest needs to be honored first. And that is something that does not happen in contracts. Contracts do not have a temporal ranking. And to give you an example of this, I think the best way to do it, it's also the way the book does it, is through some bankruptcy scenario or some debt scenario. Okay, so here we have a person who is creating a lot of debt. See, he buys on credit from MediaMarkt. He buys a house on credit. buys a car on credit. He enters, he even enters a tort debt because he has an accident with the new car he bought. He runs over the fence of somebody and now he has to pay for that too. And he has all of these credits against him. Now, what happens? Of course, this person has all these credits, but he also has this limited amount of money. Now, some creditors are faster than others in knocking his door. So let's say this guy is very fast, he's very prudent and has his lawyers move very quickly. This guy the same thing, and then they come here and they recoup their losses. So they get, let's say, 200,000 and he also gets 200,000. By that time, he's running out of cash. But then what happens to these other three guys? Now they realize he's running out of cash, and now they come and, okay, well, it's certainly possible that they may end up empty-handed, and they cannot really complain against them. Hey, you came here first. Why didn't you wait for us? Well, they didn't have any obligation to wait for you. So essentially, we could call this a little bit of a law of the jungle in getting your debts satisfied. I always give the example of a piñata, where it can happen that you break the piñata, the candies fall onto the floor, and everybody starts to fight for the candy. There's no guarantee that you will get good candy. You might get very little if the bigger children are there first, or you might get almost virtually nothing. So this is, let's call the situation chaotic. It's not ordered. On the other hand, when debts arise, when credits and debts arise in the field of property law, then you have a situation where there is a ranking, a temporal ranking. So first of all, if you, let's say, amongst these various credits that this guy had, he had bought a house and the house had a hypothec. Now, the first thing that you would want to say here is that by virtue of having the hypothec, that person, the creditor that has the hypothec, gets out of the law of the jungle system. Because he says, whatever happens in that piñata, that house belongs to me. Whatever happens in that piñata, whatever this guy A, C, D, and E are able to recoup, I know that house is for my loans. So that is the first advantage of having a hypothec. It's like a separate accounting system. Now, that's the piñata over there, but my mom has this piece of cake reserved for me. So whatever happens in the piñata, that's there for me. Okay, that's the first thing. But then the other thing is that these hypothecs, if there were more than one hypothec, there would be ordered in order of arrival. Let's say it would be the oldest one going first. And this is, again, a little bit technical because it's a world of finance. But if you have a house that's worth $1 million, you can have a hypothec for 400,000, right? But then your house is actually worth more. You still have some powerful security right there. And you say, hey, I want another loan. I want another loan, for example, to make a business. Then you could make a second hypothec, let's say for 200,000. In fact, you could, if you want, let's say, to buy, let's say, and refurbish your house or make some other expense, you might even be able to convince a bank to give you a third hypothec for 50,000. Now, then if things don't go right and eventually you default, what's going to happen is that the house is going to get sold. And the way the credit is going to proceed is that the first creditor, the guy that had the first hypothec, would get all the money up to 400,000. So he would recoup all his losses up to 400,000. Now it's the turn for the second creditor. The second creditor would try to recoup all his losses up to 200,000, and then the third creditor would try to recoup all his losses up to 50,000. So follow me here a little bit with the math. Let's imagine that when the house is taken away from you and it's sold, because it's quite often happens that when this occurs, houses get sold for less of their nominal value because they are sold, let's say, sold in a desperate situation. Let's say the house gets sold for 620,000 euros. So what will happen? Who will get his full credit recouped? First creditor, yes, he gets his 400,000. Second creditor, yes, he gets his full 200,000. And then how much would the third creditor get? Well, the rest. He would get 20,000 and no more. But then you see he gets less because he's the third one in line. And then prior tempore, whoever's first gets full recoupment first, then whoever's second, then whoever's third, and so forth. They go in temporal order. Not so here. Not so in the chaotic situation of just, let's say, the law of the jungle when there's no property involved. Of course, there's special rules if you actually go into real bankruptcy. There are priorities. For example, it will be very common that the debts of workers have to be paid first, but that's super technical. That's enough for our purposes at the moment. Now, here goes the question of how you acquire property. And this is a funny question because you'll note that when you reflect about it, you will reflect about something that is a real big truth of our present social life, is that actually 99.9 of the things you have acquired them through transfer. You have acquired 99.9 of the things you have because somebody else sold them to you. The reality of our existence right now is that it's heavily dependent on industry and commerce, and there is very, very little that you have just because, let's say, you're literally the first person to have that material. Most things we bought from somebody else. So because that is actually the most common way to acquire property, I'm going to explain it first and defer original acquisition for a little bit later. So how do you acquire property to transfer? Now, the rule there, the magic rule, is the nemo dat principle. The nemo dat principle says that you acquire property to transfer if you have a valid contract from somebody else who first originally owned the property. So let's say I am the owner of this computer because I originally bought it from Media Market, who in turn bought it from this large scale business to business sales company, who originally bought it from, let's say, Lenovo manufacturing somewhere in China. And then how is it the case that I am the valid owner? Because I can trace back this chain of ownership to, let's say, the person who first manufactured this machine. And then what happens, for example, if the computer gets stolen from me? So here's the theft, and there now we have a thief who says, okay, he has the computer. The thief goes in the black market and sells the computer to a very shady store. The shady store in turn sells it to, let's call him Robinson. Now, do they own the property? Do they own the computer? The answer would be no for all cases because of the application of the nemo dat rule. That is, you cannot transfer what you don't have. The thief got the computer, but he could not get the property, it was not transferred. Then he cannot transfer it to the shady dealer, and the shady dealer cannot transfer it to Robinson. So essentially, acquiring property to transfer is a matter of having legitimately acquired it from the person who had in turn legitimately acquired from the person who in turn legitimately acquired, and so forth until we get to the beginning of the chain. So this is the so-called chain of ownership. But then how do you acquire something for the first time? So we said the chain of ownership says, okay, I am the owner of something because I got it from somebody else who was the owner, because he got it from somebody else who was the owner, because he got it from somebody else who was the owner. But at some point we must hit rock bottom and we must ask yourself, but how did it happen that this person who's first in the chain of ownership, how did it happen that he became the owner originally? Now, the answers are in the book in the different ways of acquiring property as original acquisition. And I think now this has been detailed enough that we should not need to go through all of them. No, but for example, I will give just two. In the case of the Lenovo computer, the answer would be because you make it, because you manufacture it. So then you create this new thing here in your factory, and then that's yours. That's yours originally. You created it. Another easy way would be simply what's called occupation. And now that's not something that would happen very frequently in the modern world, but occupation is, for example, if you are fishing or hunting in a, let's say, in a wild terrain that where the animals have no owner, and you catch a fish, then that fish, which was nobody, becomes yours. You claim it, you have the power to claim that fish originally as yours. Now, these are very classic ways in which one can become the owner of something essentially for the first time. Now, you will note that this one does not appear to be 100% logical, because Lenovo does not manufacture the computer out of thin air. Lenovo manufactures the computer out of parts. Those parts may even be very expensive. For example, the chips, the motherboards, the memory, right? And then you would hope that Lenovo would have bought these parts from somebody who had the ownership of these parts and so forth, and then you would have a chain of ownership there, right there too. Now, I want to leave this complication under brackets because that is true. But what will typically happen with something that's complex and manufactured like this is that you would say, okay, this is the manufacturer of this property. With regards to these parts, this would be true. You would have to be the owner. But what will happen now, if, imagine this a little bit outlandish scenario, that one of the parts was sold by a shady dealer. No, it's not that. It's not so much that you will say, okay, now destroy the computer and give me the part. It will, at that point, it would be an issue of compensation, because the manufacturing is so technical and so complex that you have the idea that essentially you have a new thing, that you cannot rip out the silicon and give it back, but you have to pay compensation for the materials that were used that were not really yours. But with that, let's not complicate it too much, and let's just get the idea that this chain of ownership where we acquire stuff, us normal people acquire 99% of our stuff to transfer. Naturally, there must be some initial acquisition of property, because that would, without it, transfers would not happen. That original acquisition of property will have to be one of the modes, of the legitimate modes, like occupation, accession, and so forth. Now let's go back a little into the issue of transfer. So we said property needs to be transferred. There must be some contract through which somebody who has the property transfers the property to somebody else. And there we saw the chain of ownership. Now we need to complicate this a little bit now, because as it happens, when I said there needs to be a contract, you might need something else. In practice, there are two systems for transferring property: tradition and consensual. Now, to give you this example, now let's imagine you're buying a book from Amazon headquarters. Let's imagine, I don't know where it is located. Let's imagine it's located in Los Angeles, and you are way over here in Maastricht. So it's late in the evening, you click the button, and then you buy a book from Amazon headquarters. Then Amazon headquarters is the legitimate owner of the book, and you buy it, so the chain of ownership is no problem. You would become the owner of the book. Now, the question is exactly when. Do you become the owner of the book at the minute that you click and then you say, yes, I buy that book? So that would be, let's say, over here, the yellow X. Or do you become the owner of the book much later, when Amazon gets to your house and gives you the book? When do you become the owner of the book? Well, the answer here depends on whether the system of law claims that for property transfer, a contract is enough, or if tradition is necessary. When it says that a contract is enough, that is so-called the consensual system of property transfer. Then once you have perfected the contract, you become the owner of a book that's way over here in Los Angeles. You are the owner of that book that's way over there. Remember then that property ownership is an immaterial relationship with a thing. The fact that you do not have material control over the book is insubstantial to the fact that you can be the owner of that book over there. If you have a tradition system, by contrast, you are not the owner of the book until tradition takes place. Now, tradition essentially means, it's not always, but typically means exchange of hands. When the book passes hands from Amazon to you. So the moment you pick it up, you put it in your hands, now you're the owner of the book. Then what the contract created was simply an obligation on Amazon to give you the book, and you become the owner of the book the moment it reaches you. Now, tradition and consensual systems may sound like a little bit very technical, but a lot actually depends on this. At least, let's say, if we don't add any complications like special contracts, Incoterms, insurance, and so forth. Actually, a lot depends on this, because you see, between Los Angeles and Maastricht, we have a great span of territory. We have the Atlantic Ocean, and a lot of bad things could happen at that time. So, for example, we could have this big tornado right here, this big typhoon, which completely destroys the book. Now, if you are operating in a consensual system, when the tornado destroys the book, the tornado destroys your book. The book is yours. Now that Amazon bought, now that the contract has been made between Amazon and you, that book is yours, even if it's way over there in Los Angeles. So you could say that the consensual system creates more risk for you. On the other hand, if you're in a tradition system, when the tornado destroys the book right here, right in the middle of this oceanic voyage, the tornado destroys Amazon's book. You are not the owner of it, and it may be the case, depending on interpretations of the contract, that Amazon still has an obligation to send you a book. That, as I said, depends on the interpretation of the contract. But the essential point here is that tradition and consensual systems will change the balance of risk between buyer and seller. And if you're not talking about a book, but rather you're talking about a container with 100 motorcycles, then you really want to know when the risk will pass from buyer to seller. So that can be actually quite important.